Hello, students of Chan Division of Occupational Science and Occupational Therapy. I am Donaldson Santos. I'm an Associate Director of Licensing at the USC Stevens Center for Innovation, and it is my pleasure to be a guest lecturer on the topic of intellectual property. Professor Sukli Liu, thank you for inviting me to participate. The video that you're about to see today is an introduction to the USC Stevens Center of Innovation and a primer on intellectual property. The video you're about to see today is an introduction to the USC Stevens Center of Innovation and a primer on intellectual property. At the end of this video, my hope is that each of you will have a general understanding of the USC Stevens Center for Innovation, how we manage and commercialize USC's intellectual property, and have a basic knowledge of the types of intellectual property. So let's get started. Here is the general outline of the lecture today. I'll give an overview of the USC Stevens Center for Innovation, give you some points as to why intellectual property is important, discuss the different types of intellectual property, and then finally, talk about the USC Stevens Center for Innovation's commercialization process. I am going to start with an overview of USC Stevens Center for Innovation and start with describing our mission, our history, our approach, and a summary of our functions and services before focusing on intellectual property. Our mission. Our mission is to maximize the translation of USC research into products for public benefit through licenses, collaborations, and the promotion of entrepreneurship and innovation. There are three primary ways we deliver on this mission. We serve as a university-wide resource for USC innovators. We manage the commercialization of USC-owned inventions made by USC researchers. We foster innovation through various programs like our Technology Advancement Grant for USC researchers, and for students, the Student Innovation Showcase, where entrepreneurial students share their company ideas and where winning ideas could be awarded cash or legal services to support the company's development. I'd like to touch a little bit on our history. Originally, the office was in the Viterbi School of Engineering, but it was moved to the Office of the Provost to reflect broader focus on all academic disciplines. The office functions in the same way as the tech transfer offices of major universities. We are not called the Tech Transfer Office because the name USC Stevens Center for Innovation is a result of a $22 million endowment by Mark and Mary Stevens in 2004. Mark Stevens is a USC Viterbi School of Engineering alumnus and a current USC trustee. He is a top-ranked Silicon Valley venture capitalist and a long-time university benefactor. Mark Stevens is currently the managing partner of S Cubed Capital. He is also a special limited partner and former managing partner at Sequoia Capital, a global venture capital firm based in Menlo Park, California. In addition to this endowment to our office, Mark and his wife, Mary, also donated $50 million to endow and name the USC Mark and Mary Stevens Neuroimaging and Informatics Institute. Our approach. We focus our activities on technology licensing. However, developing corporate collaborations and partnerships is also an important part of our work. The goals for both licensing and collaborations are to help the university share its knowledge with commercial organizations, to commercialize USC technologies, and to establish relationships with industry and formulate partnering strategies for success. Our functions and services. As you can see from this slide, the Stevens staff handles a variety of responsibilities related to USC-owned IP. I'll touch on those responsibilities in a second and first explain what is USC-owned IP. In general, the university is the owner of intellectual property created by members of the university community, which is created or developed during the course of an individual's responsibilities to USC, including works made for hire, or is created or developed pursuant to a sponsored research agreement, or pursuant to a written agreement to transfer ownership to USC. The university also owns intellectual property created or developed with a significant use of university facilities, funds, resources, or supplies. What doesn't the university own? Members of the university community own intellectual property that is developed on their own personal unpaid time in the absence of any sponsored project agreement or other agreement giving rights to USC, and only incidental use of university funds or facilities. For USC-owned IP, our technology commercialization and licensing team perform the following functions and services: invention disclosure management, patent strategy, filing and maintenance, proof of concept funding, research reagents transfer, intellectual property licensing, and targeted marketing. Our corporate collaborations teams helps business partners navigate the vast landscape of cutting-edge innovation at USC to identify and access resources that are of mutual interest and to help stimulate industry research funding at the university. Now, on to discussing intellectual property. Now, on to the discussion on intellectual property. I'm going to start with asking you all to think about why intellectual property is important and why protecting it is important. Take a few seconds to think about that. Here are a few important reasons why I think intellectual property is important and why protecting it is important. Intellectual property protection is critical to fostering innovation. Without protection of ideas, businesses and individuals would not reap the full benefits of their inventions and would focus less on research and development. Artists would not be fully compensated for their creations, and cultural vitality would suffer as a result. IP protection incentivizes. It's hard to imagine a world without intellectual property protection. Without IP protection, drug development would suffer, and few life saving drugs would be developed, or not at all. Technology would suffer. You probably don't have Apple, Tesla, or Google. Without IP protection, your favorite books, music, or movies may have never been created. Industries do not generally blossom where patent rights are prohibited or not enforced. Now that you have some idea of why IP is important, I'm going to transition into discussing the different types of IP, which includes patents, copyright, trademark/service marks, and trade secrets. This slide shows you the types of intellectual property and what is covered by that class of intellectual property. Patents can cover ideas like processes or methods, composition of matter, and compounds. Copyrights can cover your favorite song or book. Software is also covered by copyrights. Trademark. Your favorite brands or words and phrases may be covered by trademark. Think USC or FIDON. Notice that the circles do overlap in a small area. That is because it is possible for an asset, invention, idea to be covered by different intellectual property types. Simple example is software. Software can be covered by copyright and in some cases by patents as well. The decision to choose one or the other or both depends on what maximizes the commercial opportunity of the software. So where does this idea of IP protection come from? The basis of our patent and copyright system and even our trademark system is covered by the Constitution of the United States. More specifically, Article 1, Section 8 of the Constitution. The Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to the respective writings and drawings. This clause is one of the reasons why the United States is as strong as it is economically. In the next few slides, I'll be focusing the discussion on the specific types of intellectual property. I'll be starting with patents. Here's some basic information about patents. Patents are governed exclusively under federal law. Patents protect ideas, contrasted with copyright concept, which protects the expression of an idea. You have to apply for a patent. It can be very costly. It can cost anywhere between $8,000 and $25,000 on average, depending upon the subject matter. There are 5 substantive requirements for patentability. They are: subject matter has to be patentable eligible. The invention has to be new, useful, and non-obvious. And when you write the patent, there has to be adequate description of the invention. And as I mentioned before, you can file on new processes, machines, products, composition of matter, which are things like compounds and drugs, designs, plants, new and useful improvements of things that have already been patented. Patents are effective and enforceable upon issuance, but the life of a patent is 20 years from the filing of the patent application. Some of you might have seen on some products this thing called patent pending. Patent pending is a marketing mark that serves to notify the public, businesses or potential infringers who would copy the invention, that they may be liable for damages once a patent is actually issued. So the copycat can actually start selling products, but once you have an issued patent, you can go after them for things like damages. You can stop them from actually selling it, or you can actually seize the products themselves. An interesting concept about patents that people are not aware. Some people think that a patent is the owner, it gives the owner a right to use the subject matter covered by the patent. It doesn't. Patent rights are exclusive rights. They essentially give the owner the right to exclusively, or sorry, the owner the right to exclude others from making, using, and selling the content claimed in the patent, which is an interesting concept. Um, you must file a U.S. patent within 1 year of a first public disclosure. If you want worldwide rights, you should file a patent before you publicly disclose the invention. Um, the the patents are considered in some ways as a government contract. For the rights of exclusivity or having a monopoly for about 20 years, the government will give you that issue a patent provided that you disclose the invention in its entirety to make it available to others. And the idea behind that is that it spurs innovation and improvements. And the hope is that new and better products are developed and new and more interesting products are being sold. So it helps to foster innovation essentially by the government allowing inventors to have a small period of time monopoly. The next few slides, I want to talk about the requirements for patentability in a little bit more detail. One of the first requirements for patentability is that the subject matter has to be allowable in terms of patentability. So in the US, it's been virtually everything in the US has been viewed as patentable subject matter. And so you can almost patent everything, including things like living matter, genes, and some software. What's not patentable are laws of nature, natural phenomenon, and abstract ideas. Um, the second of a requirement for patentability is novelty. So the invention has to be new. An invention is not normally patentable if the invention was known to the public before the applicant filed for a patent application. An invention is not normally patentable if the invention was described in a printed publication before the applicant filed for patent protection. And an invention is not normally patentable if the invention was described in a published patent application or issued patent that was filed before the applicant filed for patent protection. There is an exception in the United States to the above conditions if a disclosure is made by the inventor less than 1 year before the patent application was filed. And so a practical example of that happens quite a bit in the university setting is when a investigator or researcher files or wants to publish an idea and it's going to get published in Nature or something like some other journal. And so if you are only interested in the US rights, you have 1 year from the publication of that particular journal article to file a patent. And so we have or experienced that quite a bit in the office because that's often a patent bar that we have to think about when we're thinking about whether or not we want to file internationally. So in the US, you have a grace period essentially of filing within 1 year. But outside of the United States, if you were to publish, for example, today, you couldn't capture the world. And usually things like drugs, you want to hopefully capture as much of the world as you can. So it will help in terms of commercialization and finding someone who's willing to develop. Most companies aren't interested in developing products or drugs in a single country, for example, like the United States, even though it's one of the biggest markets. They may pass on it and for another asset that has a wider geography in terms of patent protection. Another requirement for patentability that's pretty self-explanatory and pretty simple. The invention has to be actually useful. And so the invention has a well-established utility if a person of ordinary skill in the art, and an example of someone ordinary skill in the art would be one of your colleagues, would immediately appreciate why the invention is useful based on the characteristics of the invention. For example, the properties or applications of a product or process, and the utility is specific, substantial, and credible. So basic premise here is it's got to be useful, and somebody should be able to recognize who's a ordinary skill in the art, like your colleagues, be able to recognize that it is useful. Another requirement is non-obvious. The invention has to be non-obvious. So what does that actually mean? This determination is also made by deciding whether the invention should be obvious to a person having ordinary skill to which the claimed invention pertains. In other words, the invention compared to the what's called prior art, and a determination is made whether the difference in the new invention would have been obvious to a person having ordinary skill in the type of technology used in the invention. So if your colleague were to look at your invention and say that's pretty obvious that that's a natural design or invention based on what's been done before, it's going to be a little bit difficult to maybe get the patent through the patent office. And a practical example would be, as an example, sodium chloride, table salt, and potassium chloride, a chemically similar salt, can often be used interchangeably. Chemists working to improve road salt would consider it obvious to substitute potassium chloride for sodium chloride. So a formula that simply made this substitution in an already patented road salt formula would not be patentable. So somebody who's familiar with what it is that you do, if they recognize it as something that would be obvious, then it's quite possible that the patent office is going to look at it the same way, and the patent office is going to reject your patent application based on this particular statute of requirements for patentability. The final requirement for patentability is an adequate description of the invention. So the patent office is going to read your patent, and they're going to look to make sure that you described it well enough for somebody skilled in the art to recognize that the inventor actually possessed the claimed invention, that it was essentially invented by them, and that they actually have it in hand. It's not entirely an abstract concept. So the last few slides were pretty much a description of what the patent office sort of looks like when they're judging the patentability of a particular invention. I'm going to talk a little bit now about the flowchart for a patent and sort of the process. This is a very simple flowchart because there are many sort of avenues that can other boxes and other directions that can do it depending on the case. But generally, this is sort of the flowchart that happens with most patent applications. So most of the time, as an example for us, we file a U.S. provisional patent application, and within 12 months, we would file a non-provisional or a full utility patent. That's also the name. And then going down further down to the fourth box, it actually, you send it to the patent office. The patent office will take a look at it and judge it for all of the patent requirements that I mentioned in the previous slides. And if they reject it on one of those grounds or any of those grounds, they will report it back to the applicant or the applicant's attorney. And there's a sort of a back and forth of arguing whether or not there is a way to overcome what the patent examiner is saying or is rejecting the patent. So as an example, the patent examiner might say to the applicant that they think the invention is obvious. And what the applicant will do in a response to what's called an office action. So an office action is anytime the patent office sends a correspondence to an applicant. In this case, it's to discuss why a particular claim or the patent is not patentable. The applicant has an opportunity to argue back and forth with the applicant. It costs money every time, so the process can take sort of this flowchart can take anywhere between 2 and 5 years, and costs anywhere between, like I said, $8,000 to $25,000. It can get really expensive if the patent examiner has rejected you every time, and you decide that you want to go and try to appeal to an appeal board. And that costs quite a bit. Most of the expenses are related to legal fees that you would pay an attorney, not necessarily the fees for getting a patent. There are fees associated with that, but a substantial amount of the fees are legal services provided by a patent attorney. So this is a brief sort of a simple flow chart for you all to take a look at. It's often the way that things happen in our actually office. We actually get like first office action, we respond, then we get a second office action, then we respond, and then there's a kind of a back and forth, and it can loop. There could be some loops to this where we're coming back, changing some of the claims, and then they're going to review it again, and it goes back and forth. So it can get quite expensive, and it could take years before you actually get patent. And then a lot of patents can take, again, 2 to 5 years, depending upon the subject matter. I'm going to now talk a little bit about what an actual patent looks like. So I'm going to talk about the anatomy of a U.S. patent. So broadly, a typical patent consists of like 4 main parts, which is the front page, the drawings, the specifications, which includes the background section, a list of drawings, detailed description, the best way to practice the invention, and finally the claims. And I'm going to just briefly go through what each of these sections looks like. And I have a patent application on a cane that I'm going to share with everybody so that they can have an idea as to what patents look like. So here is an example of a U.S. patent. It's for an adjustable cane with a built-in pickup means. So the front page contains things like the title, the abstract, the drawings, the inventors, where they're located, and who owns the patent. And if you look there, you can see under the foreign patent documents section who actually examined the patent at the U.S. Patent Office, and who the attorney was in the U.S. That actually, we call it prosecution, or just move the patent forward with the patent office, and they actually provide those names. And then the abstract, which is pretty much a description of what the invention is. They are not the primary sources for, so this section doesn't really tell you what the patent actually covers. That's laid out at the claims at the end of the patent. This sort of sets the story as to why why the applicant filed for the patent. And let's see here. There is some other things in the patent. There's this thing called the specification, which is a description of the preferred embodiment. So you have to describe, it's the techno-legal part of a patent that contains the full scientific details of the invention and describes the background of the invention and best embodiment of the invention. So the patent examiner takes a looks at this, and it determines what you can claim in the patent, which is essentially the embodiment of the invention, and that's what you're going to be using against infringers. People have to violate the claims, which are in the back of the patent, in order for you to enforce your patent against an infringer. That's where they look at things, and the patent examiner is taking a look at all of this to make sure that you've described in this section what you're trying to claim in the claim section. Here's the example of the claims in this particular patent. The most important part of the document, the claim sets forth and define the patent scope of exclusive rights. In other words, they describe what the patent does or does not cover. Each claim element should be shown in the drawings and described in the detailed description. So you can't create a new invention in this section if it wasn't already described in the previous sections of the patent. So this is just a little brief overview of patents and what is patentable and what's not. I'm going to go ahead and shift gears, and we're going to move on to a different form of intellectual property, which is copyright. And so we will be talking about things like software and music. The next few sections on the most complicated of intellectual properties is probably patents, because there's a longer process for that. The other forms of intellectual property, including copyright and trademarks and service marks, are much more simple. And so, but we'll, so if you have any sort of questions about this, feel free to reach out to me. I'm happy to answer things about patents. We are now going to talk about copyrights, trademarks, and trade secrets, the other forms of intellectual property. And we're going to breeze through them because they are less complicated than patents and are easily explained by a handful of slides. So let's start with copyright. What is copyright? Copyright protects original works of authorship, including literary, dramatic, musical, and artistic works like poetry, novels, movies, songs, and computer software. What does copyright grant to an author? Copyright law grants the author or copyright owner an exclusive right to reproduce, make derivatives of, sell, distribute, publicly perform, or display the copyrighted work. Copyright owners may retain all these rights described in their copyright or give limited licenses that allow others to make specific use of their works. For example, if I author a book, I can grant another party the right to sell or distribute my book under a license. So how do you get a copyright? Copyright is automatic, so it applies as soon as a work has been created. Once you write it down, paint it, draw it, it is automatic. How long does it last? Unless otherwise granted, copyright protection in the United States lasts for the life of the author plus 70 years. After this period has expired, works fall into the public domain and are free from copyright restrictions. So there you have it. Um, Copyright's pretty simple. That's all for copyright. And now we're going to go on to trademarks and service marks, which are also very simple. So what are trademarks and service marks? Uh, Trademarks and service marks are a way to identify the source of goods or services. And you can use things like a word or a phrase, a symbol, a sound, or a color. If you look here, I have a couple examples of some trademarks. HBO, the Apple symbol, USC has several trademarks. Oreo cookies is a trademark. And all of these examples have, either a word or a phrase or a symbol. Some no sound, and but there are a couple of examples of ones with color. Um, what is the purpose of the trademark? They're supposed to help distinguish between goods and services of one entity from goods or services of another company. So the trademarks are a way to protect against essentially consumer confusion. It helps distinguish the source of the goods or services. Trademarks are potentially perpetual. They're given in 10-year increments. You have to actually pay every 10 years to continue on with your trademark. You must aggressively protect it or it's actually gone. So you have to be careful about that. There is a difference between some of the markings that people might see as it relates to trademarks. So there's a difference between an R in a circle versus the letters TM. So the R with a circle means it is registered with the United States Patent Trademark Office, and it means you've got legal protection throughout the United States. Without the R, there could be multiple companies or brands using a trademark in the same country or even the same state across different industries. That could create sort of confusion if you wanted to try to distinguish your particular product. So having it registered with the USPTO is probably a smart thing to do if your particular product is one that is going to be everywhere in the United States, for example. That's pretty much all to say about trademarks, and we're going to go on to trade secrets, which are also super simple. So the ideas behind trade secrets, those are covered predominantly by state laws. The owner of a trade secret must be very careful and control it very tightly. You can virtually have trade secrets on any kind of subject matter, and it's potentially perpetual. So as long as you keep it confidential and leave it to a few people, then you probably can have it keep it secret for a long time. But once it's disclosed, even if it's stolen, the protection ends. Some examples of trade secrets are the formula for Coke, the formula for Dr. Pepper, or the recipe for KFC. So trade secrets are super simple sort of ideas. If you have, and really relate to things like recipes. Um, but once it gets out there, no matter what happens, it's if it gets out there, it's no longer protectable, and people will often have very tight confidentiality agreements with people who have access to these kinds of things. And in general, most technical type of ideas or inventions don't lend themselves very well to trade secrets, especially in an academic setting. The whole goal of the academic enterprise is actually to publish as much information as possible. So, trade secrets are something that you don't find generally in the academic world. So we've covered the different forms of intellectual property. I hope you learned something about patents, copyrights, trademarks, and trade secrets. I now want to talk about how USC Stevens commercializes intellectual property. So the next handful of slides, we're going to talk about generally the process by which we do in the office to get things out there for the public benefit. Now that you have the basics of intellectual property knowledge under your belt, let's talk about the USC Stevens commercialization process. There are a number of steps involved in the commercialization of a USC invention. We look at it as an 8-step process. It starts with step 1 and hopefully ends in step 8. I am going to briefly talk about each of these steps and provide you a little bit more detail in the following slides. Step 1. It starts with the USC scientific discovery and includes things like research tools, inventions, databases, and software. We have commercialized these types of discoveries listed here, but not every discovery gets commercialized. Commercialization is highly influenced by market forces, so some great discoveries may just be great science and not necessarily great products. USC in general generates quite a bit of intellectual property, and most of them fit in the intellectual property buckets of patents and copyrights. So step 2, our office needs to know about the technology to be able to commercialize it. So the next step is disclosing the technology to our office. And we have a secure online portal that USC researchers use to disclose their discoveries and inventions. It's simply log into Sophia with your USC Net ID and password and enter in the necessary information for us to go on to the next step of step 3. But before I do that, I'll just share with you how this is actually done. On our website, we have a disclosure invention icon at the bottom of the front page. And this starts the process of disclosing your invention to our office. Pretty simple sort of process. It's just a couple of clicks. And the form itself is pretty short and simple. We ask the inventors to disclose who the inventors are, give their full names, a brief description of the invention, how the invention was funded, and how is revenue going to be shared between all of the inventors. Because if we are able to get to step 8, which is get revenue from licensing of an invention, we do share some of the revenue proceeds back to the inventors. So maybe some of you are asking why even bother disclosing to the office. Well, there's a couple of reasons why. Some of them are legal and some of them are not. So I'm going to start with the sort of easy, simple ones. And I think the one that I think that comes to mind for me is that sometimes protecting the innovation is the best way to get a technology out there. Companies won't invest in ideas if there's not patent protection. So, and as an example, drug development is very expensive. If you don't protect the intellectual property, then it's unlikely companies like Pfizer or even a small VC who wants to do startup are going to be interested in that because there is no patent protection around, let's say, the new drug. And reasons to also disclose: these companies provide opportunity to boost local economies in some cases or create new jobs. Those are other reasons why you should disclose. There's a public benefit result when there are jobs created from your technology. As I mentioned before, there is also the financial incentive to actually disclose. Uh, Inventors do share in any proceeds that we're able to get from the licensing of a technology. So those are some of the non-legal reasons why you should be disclosing. One of the big legal reasons why you should be disclosing is that if your technology was federally funded, you may be required, or the university is required, to notify the government that an invention was made. So the Bayh-Dole law is the federal law that is related to inventions created using federal funds. USC, like most universities, have a lot of federal research dollars. And as recipients of these dollars, we have an obligation to the government to report things like inventions. Um, the other reasons why disclosing is important: it attracts and retains scientific talent. You can attract corporate and other external research support. So you might be able to get a company interested in funding more research in your lab. And then obviously the big one is generate licensing revenue to further research uh, to further research um, uh, in the university setting. When should you disclose? So that's an important question to answer. The timing is critical. You should disclose as best you can 90 days prior to any public disclosure. And the reason for that is that it could affect patent rights if the invention is patentable material, and if it's the right thing to do for that technology. Now, again, not every disclosure or invention needs a patent to fulfill or to achieve commercialization. And but if it does, we would like to know as much as possible ahead of time so that we can put in any proper patents in place. And we work with a lot of different patent attorneys in specific fields to help us craft the best type of patents. And keep in mind, this is all at a no cost to the USC inventors. So that is sort of a overview of our disclosure process. And what I'm going to move on to next is step 3, which is the preliminary review. After the disclosure is submitted to the office, a licensing associate is assigned to review the information. And what the licensing associate will do is determine whether to file a patent application on the invention, whether copyright's the best intellectual property to have on the invention. The licensing associate will then interview the inventor and research the market and do some competitive analysis and prior art searches on the technology. Prior art is looking at what has been done in the past to see how products that are similar have fared and whether or not the invention is actually new. And sorry, I forgot to maybe mention what a licensing associate is. So the licensing associate in our office is the one of the licensing professionals who are tasked with reviewing disclosures and actually finding a licensee and negotiating with a licensee. And everybody in our office has a technical background for being able to analyze these kinds of technologies, and each one has a specific specialty in the type of industry that they are focused on. And so wanted to talk a little bit about what happens in the preliminary review. So the licensing associate will take a look at the disclosure and take a look at things like the overall patent landscape that the disclosure relates, what the addressable market, what the market opportunity is. These are the things that we look at to determine whether or not we file a patent. When appropriate, the university may decide not to go in the directions of patents and may utilize copyright or trade secret or trademark rights to commercialize a university invention or works of authorship. And I'm going to dig a little bit more deeper as to the kinds of questions we ask or thinking about when we're deciding to patent something. So we take a look at the patent landscape in a little bit more detail. there any inventions already describing your idea? So one of the requirements of patentability is it actually novel and new? So that's one thing we look at. Are there patents that require you to take a license to practice your invention? So a lot of people sometimes use material that they borrowed from someone else to figure out a new invention. An easy example of that is if someone did some research on a drug and figured out a new use for it, the original provider of that drug may own the drug itself, the composition of matter in a patent, and you maybe figured out a new use for it. Maybe originally it was good for cancer, and you decided it was good for some other disease, maybe just randomly, maybe for macular degeneration, which the original owner of the compound didn't know about. Well, we couldn't license that very easily because we don't actually control the compound. So that's something that we have to think about. And then there are other types of considerations that we look at. The last two bullet points is related to, will you be able to enforce your patent easily? So if the if it's a method, for example, that might be difficult to know whether or not somebody uses your method. That is something that we consider as well. And then obviously the last one is if you've already published on it, that's something that's a patent bar, and you have 1 year to file within disclosing that invention to be able to patent it. And if that's passed, then you are not able to do it. So we take a look at that very closely to make sure that we are within the statutes of being able to file a patent. And we also take a look at the market considerations. We take a look at the background on the problem. And so what is the problem? And generally, how do you approach it in terms of trying to solve it? We look at things like market size. So what is the market size of the technology? Is it $100 million or it's $100,000? There are inventions that we have that might be more like of a catalog type of invention, where it's just a handful of people or a handful of companies that might sell it, and they might generate $10,000 or $20,000 a year at the most. Well, patents can cost $10,000 to $20,000 per country, and so it may not be the best thing to try to do is file a patent on something like that. And we have to take into consideration the overall size of the market. We also take a look at the competition. How easy is it going to be for this particular idea or invention to penetrate the current market, and what kinds of competitions are there? And then we also take a look at what the path of development is. There are costs related. Different industries have different costs, and some industries have regulatory issues that have to be addressed. As an example, the drug pathway requires FDA approval. Other types of technologies like software don't require necessarily FDA approval. So the barrier to entry and the timing to get into the market are very different. And so revenue could be generated from things like software very quickly, whereas a drug will take maybe 10, 15 years before any revenue is realized. So we look at sort of all those things to see how it plays out. So remember, I guess as to the regulatory issue, I wanted to just comment, like, for example, if it'll take 15 years to develop a product or get it to a patient, and takes another 4 years to actually get into sales, you've essentially lost all your patent life, and there's nothing really left for in terms of protection. So these are kinds of things that we kind of look at and make sure that for timing wise, we are going to be able to realize some revenue in the time that, for example, the patent's alive. So these are things that we sort of want to be sure about now when we take a look at the technology as to what the opportunity is. Let's see, what next thing I want to talk about is step 4. So after that diligence, after interacting with the inventors and learning more about the technology and doing our own diligence, we'll decide what the best sort of technology, IP protection there is going to be on the technology. So it will likely fall into the copyright or patent bucket. And those are the two main ones that we deal with in office. Probably 99% of them fall in that space. And not everything, again, that is protected through copyrights or patented. And we try to do the best in terms of maximizing the opportunity because the patents, again, only last 20 years, where copyright can last up to 70 years after the death of the author. So there's quite a difference in terms of revenue that could be generated from a particular technology based on whether or not you file patents or have copyright. Once we've decided the best sort of IP protection on the technology, we move on to step 5. We contact industry leaders, companies, entrepreneurs, and investors who may be suitable partners to get feedback on the technology, both through sort of our business contacts, inventor contacts, industry events and conferences, and online. We market our technologies on our website and try to essentially find a home for them. Here are a couple of the sort of companies and venture groups that we've interacted with on technologies. Some of these companies and venture capital groups have licensed technologies from USC. This is just a small sampling. We have hundreds of contacts. We have hundreds, maybe even thousands of contacts, but we deal a lot with the big companies and the small companies quite a bit. So we have a huge roster of companies that we reach out for specific technology. And some technologies are really niche, so there may be only maybe 3 to 5 companies that may be interested in, or there maybe just be one. So it's one of the interesting challenges of tech transfer is that not sometimes products are sometimes ahead of their time and nobody recognizes that there's a market opportunity. But we do our best to find the right partner to develop a technology, because at the university level, most universities aren't able to actually develop products. We're mostly research oriented, and so someone does need to take it out from the university to try to develop, which can include, some of the licensees can include the inventors themselves. They've decided to do a startup on their own. So that is also part of the commercialization process. So once we find a partner to who's interested in the technology, we now go on to step 6. And step 6 is the license agreement. So a license agreement is essentially a legal contract between two parties fixing the terms and conditions under which one party allows the other to practice its IP. We prepare the formal license agreement, we negotiate the business terms, and we execute on behalf of the university and the inventors the agreement. We manage the agreement. Some of the things that are memorialized in the agreement include the grant section and the compensation. So we will talk about what rights we actually grant to them. So in some cases, we might just do for that particular technology a non-exclusive license. Maybe it's the best way to get it into the hands of lots of people, or if the technology is suitable for exclusive licenses, and we'll do exclusive licenses. The field, usually most of the time, it's all fields, but certain technologies can have multiple sort of fields. So think chemistry type of processes. Those can be used in maybe a lot of different fields, whereas a single product idea probably is going to be an exclusive within one particular field. In the territory, we've done carve-outs where we've done all of the world, or sorry, not carve-outs, but carve-outs for specific countries. Generally, most licenses are all over the world because that's what is likely to be the best way for USC to realize the development of the technology. Companies oftentimes want the whole world and be able to sell everywhere in the world. We're pretty much fine with that. That's something that we encourage in most cases. The exceptions are for places that are on the sort of the bad list of countries not to work with, and I won't mention them. The other thing that you will find in the license agreement are how the university gets paid. It's the compensation. So Our office negotiates things like upfront fees, we negotiate things like milestone payments, and we actually negotiate the royalty rate. So how much are we going to get for that particular technology? So these are just 3 examples of the kinds of compensation that we ask for in license agreements. There's more, and there's a lot more in a license agreement, but I just wanted to give all of you an idea as to what kinds of things are negotiated in these types of agreements. So if we're lucky, we have a licensee. They are now, and we have a license agreement. Steps 8, 7, and 8 are really directed to the licensees or the responsibility of the licensees, although we take part in it in some form. So the path of commercialization varies depending on the nature of the invention, the market addresses, and its stage of development. So under the terms of our license agreement, the licensee is required to commercialize the invention and provide regular progress reports to the university on its commercialization activities. We want to make sure that the technology is being developed. One of the things that can happen here as well, and I think I mentioned before, USC inventors may continue to be involved in development activities with the commercial partner, and that can include things like sponsored research. So that happens quite frequently. And if all of that works and there is a product being sold, the company is actually selling products, and royalties and other revenue received by USC under the license agreement are sent to USC based on what the license agreement says. So we get maybe 3% of every sale that they get. And once they send us a check, usually once a quarter, we will distribute out that revenue to the inventors as well as the schools. So we manage that overall process of commercialization. And then these 2 steps, 7 and 8, are heavily dependent upon the commercial partner being able to both develop and sell a product. So this is pretty much kind of our 8-step process. I just touched on them a little bit briefly. I think hopefully there are some things that you learned about the commercialization process at USC Stevens that you might be able to apply in your own setting if your invention is not owned by the university. A lot of these things that I talked about are useful in terms of for you to think about if you have an idea that you want to commercialize on your own. These are kind of the steps that most inventors, no matter whether they're in an academic setting or not, that they have to sort of think about. So hopefully you guys learned something from these last few slides about our process and how it might apply to you someday or currently if you have an invention that actually is USC owned. I know this is a bit of a fast and furious lecture about intellectual property and about USC Stevens, so if you have questions, please feel free to reach out to your licensing associate or to me. To locate your licensing associate, go to the contact link on our webpage and go to the bolded term updated list on the link. This will direct you to a spreadsheet where you can locate your designated licensing associate for your department. LAs are listed by department or college. The licensing associates and myself are here to help you, so reach out, set up a meeting. They are happy to do one-on-one Zoom meetings. All researchers at USC and inventors are welcome. We are also open to students as well and can answer general questions on commercialization and intellectual property or direct you in the right direction. For more information about USC Stevens, I'm providing you a couple of different links here. We are on a number of social media platforms. Please visit us on these to learn more about what is going on at USC Stevens and about new technologies. Thank you again, Professor Liu, for letting me participate in this class. Take care, everyone, and if you have any questions, please don't hesitate to reach out to me or your licensing associate. Thank you.